matter for oral argument today is Airborn Electronics versus Magnum Energy Solutions.
Go ahead.
Gentlemen, as you know, each party will have 15 minutes to present their argument. The appellant will proceed first and may reserve up to 5 minutes for rebuttal. If you wish to reserve any time, once you introduce yourself, you'll let me know. I will assist in keeping time. We ready, please.
Thank you. May it please the court, counsel. Dean Hoover for the appellant in this case. I'm going to reserve 5 minutes for rebuttal, please. I appreciate the court's reading the extensive paperwork in this case. I don't think it's as complicated as it looks. We've tried to summarize the case in 3 assignments of error. Our first assignment of error has to do with the directed verdict, both on the plaintiff's claims and our counterclaims with regard to 3 products Magnum purchased from Airborn. The gist of that argument was that the court concluded that expert testimony was necessary to prove the cause for products not working. It was agreed that the contract provided or implied that the products delivered by Airborn would work. It was undisputed that they didn't work. The court concluded that they didn't work. The court implied an additional obligation on the plaintiff, or in this case Magnum, to prove why they didn't work. And to do that, the court believed that we needed expert testimony. This causation issue continued. The judge granted directed verdicts, and then later, the court, I think, concluded that she was wrong, but it didn't change her mind or the outcome of the case. At the transcript, volume 9, page 906, lines 10 through 14, while the court was undertaking a conference on jury instructions, read a note handed to her by Lisa Neems, her judicial attorney, informing the court that causation was not an element of a breach of contract case. And she's quite right. Because causation is not an element of a breach of contract case, no expert testimony is needed. Either the products worked or they didn't work, and they didn't work. Now, by granting directed verdict, this gave Airborn about $110,000 and deprived Magnum of about $175,000 in counterclaims. The second assignment of error has to do with the other 2 products. These products, there was some expert testimony, so she allowed these products to go to the jury. On these 2 products, the issue became the jury instructions given, and that was the applicability of the Uniform Commercial Code as opposed to common law contract claims. Both parties pled common law contract claims and counterclaims. There's no question that this was a hybrid contract. There's no question that the predominant purpose standard applied, but the way the court dealt with that was incorrect. The court just basically heard argument of counsel and decided on her own, a question of fact, that this was predominantly a contract for the sale of goods as opposed to a contract for the performance of services. This court has addressed this issue before. I've cited in my brief the 9th District case of, I don't know if I can pronounce it, it's called Valeri. It says where that's disputed, that's a question of fact. That being a question of fact, that predominance issue should have been delivered to the jury, and then the jury could decide whether to go down to UCC course with its elements or the common law breach of contract claim course.
Excuse me, I have a question about this. The products blew up.
Yes, ma'am.
Were they mishandled in any way? Was there any evidence as to why they blew up?
Well, the evidence was that they were installed, and they all blew up.
And no further investigation was done?
Oh, there was a lot.
Why they blew up?
Yeah, there was a lot of investigation. Most of that investigation came out of the mouths of admitted non-experts. They just said we.
Okay, I just wanted to clarify that. We can look through the record on
Okay.
Thank you.
Yes, ma'am, thank you. So instead, the judge made the decision that this was a predominantly a sale of goods case, and so she decided to submit Airborne's claims using the Ohio jury instructions for Uniform Commercial Code sales cases. I think it's CV 501 in that series. Magnum's argument was, well, we don't agree with that, but if you're going to submit their claims under UCC, then our claims have to be submitted under UCC also. It's either one way or the other, it's not both ways. The court decided to split the baby and offer instructions on both the UCC and the common law. We're looking for the standard in this case of whether the jury was probably misled. I don't know how they could not have been misled. The major difference between the UCC jury instructions and the common law jury instructions are that for Airborne to prevail on a common law claim, they have to prove their substantial performance of the contracts. That substantial performance included the delivery of working products. Under the UCC, it shifted the burden. Under the UCC, all they have to prove is that they delivered the stuff. And you could understand if we were talking about a railroad car full of 2x4s, that might make a certain amount of sense. The UCC streamlines the breach of contract practice just for the benefit of commerce. But in this case, it shifted the burden, and the jury could not help but be confused. Our third assignment of error has to do, some of this crosses over with the cross assignments, has to do with the punitive damages portion. We counterclaim for conversion and for punitive damages, including a separate award of attorney's fees. A motion for directed verdict was made on that also and was denied. The judge did bifurcate the case, submitted the issue of punitive damages, and the jury came back with a $50,000 award on conversion, and then came back with $135,000 additional in punitive damages, and also answered the question in the affirmative as to whether attorney's fees ought to be awarded to Magnum. In post-trial procedure, Airborne filed a motion for directed verdict / judgment NOV, which the court granted. The court was correct the first time in not granting their judgment for a directed verdict. There was quite a bit of evidence that the jury could take on the issue of whether legal malice existed. I listed that in my response to the motion for judgment NOV or directed verdict for memory, because at that point we didn't have a transcript prepared. And in my brief, I've listed that stuff by bullet points. The responsive arguments are that there's a negligence case. There's the maxim in there that you have to have more than mere negligence to justify punitive damages. I admit, that's the law in a negligence case. But here we're dealing with an intentional tort. We're not just dealing with a finding of negligence. We have a finding that these people wrongfully withheld Magnum's property. Moreover, we explained through testimony on cross-examination from the Airborn folks that they knew they were hurting Magnum by withholding these parts. That didn't matter to them. I sent a letter to their lawyers saying, you know, you guys are hurting us by holding this stuff back. We need this so we can have a different manufacturer prepare this stuff. The court excluded that letter, but allowed me to question the Airborne representative on the stand about what it contained, and he admitted that they were aware of those things. He admitted that they were withholding it to gain leverage. He admitted that the parts they were withholding were worth $50,000. He admitted that there was a lead time in obtaining these parts, and Magnum wanted to find them someplace else and take them to their new manufacturer. He admitted the new manufacturer offered to buy the parts from Airborne, and Airborne refused to sell the parts. Airborne even admitted that after time passed and Magnum was back in production with a different manufacturer, that they had lost their leverage, and they still retain the parts.
You are at your 5 minutes now. We've put you-
And I'm ready to sit down.
All right.
Thank you very much.
Thank you, Your Honor, and may it please the court, if I could please reserve 3 minutes for rebuttal, Your Honor.
Well, there won't be any rebuttal. You just get the entire 15 minutes.
Entire 15 minutes? All right, thank you, Your Honor. My name is Stephen Chang, and I, along with my colleague here, Philip Downey, represent the appellee and the cross-appellant, Airborne Electronics, Inc. Behind me to my right is Mr. David Glass, here on the bench. Mr. Glass is the former CFO of the company, formerly known as Iasco, the company that is homegrown and based here in Akron, Ohio. Your Honors, I want to begin first with the assignments of error on the cross-appeal that Airborne has asserted, and then I'll move to the assignments of error as set forth by the appellant.
Before you get started on that, there's something that I want to clarify. The trial court bifurcated the trial as between the compensatory damages and punitive damages. Am I correct?
Yes, Your Honor, absolutely.
And one of the arguments that you make in your merit brief is that at the end of the trial, the first part of the trial was bifurcated, that Magnum rested and did not then put on additional evidence of punitive damages, correct?
At the end, after the verdict was determined, yes, no evidence was presented in the second phase.
Okay, and so your argument is that there was no evidence from which the trial court could determine punitive damages, correct?
Well, there was no evidence by which the jury could point to without speculation that would support an award of punitive damages. That's correct.
Well, in the trial court, though, in its entry, goes through an examination of evidence. We can only presume that that was from the first part of the bifurcated trial.
That's correct, Your Honor. And in fact, what opposing counsel is pointing to when he is directing this court to the evidence of punitive damages is essentially the same elements for a claim of conversion, right? So he must do more to meet the burden of clear and convincing evidence sufficient to support an award of punitive damages than simply say that the items were converted. That's what was proven during, or that's what was attempted to be proven during the first phase.
Well, except that, if, let's say, this is a hypothetical, during the first part of the conversion part of the trial, a witness for Airborne says, you know, I didn't like them, I purposely, I knew that they had a right to have these things returned, you know, I had malice in my heart when I made the decision not to return, you know, something, a absurd, such as that. But, is it your position that the trial court could not take that into consideration in deciding on the motion for J&OB?
No, Your Honor. Our position is that if there is testimony that is or it can't be solicited by opposing counsel, he can't press for issues related to malice. But of course, as we all know, trials are unpredictable. If a witness
If it's
offers,
volunteer.
right, if a witness offers testimony relating to the issues of malice, then certainly we're not taking the position that the court can't consider that.
All right,
But there is no evidence here of that.
okay, thank you.
Yes. And just to that point, since we're on that issue, the only testimony that you have beyond this idea of the claim of conversion is the admission by Mr. Glass that his testimony relating to the reason why he decided to retain the parts, which was to reserve what he believed to be Airborne's right in order to collect on the balance, was for the issue. The opposing counsel points to this idea that he admitted that it was leverage. Well, of course it was leverage. Whenever a creditor reserves its rights, it can be perceived as leverage against the debtor. That is not a substitute for legally sufficient evidence that could support an award of punitive damages, and I'll expand on that point when I get to it on the appeal. With respect to the cross appeal, we would ask that this court reverse the trial court's decision to deny our motion for directed verdict on the issue of the conversion claim for two reasons. First, at the point at which Airborne was determined to be an aggrieved seller, because of the jury's determination, as well as the trial court's directed verdict, it had the right to complete the manufacture of the goods or to resell the component parts for scrap or salvage value. And second of all, Magnum failed to present any evidence on the issue of damages when it comes to conversion as to the type, value, or even what the products were. It's important to note that only 2 of these products actually went to the jury. And the jury was instructed on the conversion claim that it was only to consider those 2 products. Without evidence being able to show what amount of the $50,000 was attributed to these 2 products or were even placed into these 2 products, there wouldn't have been sufficient evidence to support a damages award in the conversion claim.
So was there nothing in the small bit of argument, I'm assuming, so there's testimony regarding a third party's offer to purchase items which had allegedly been converted? I mean, was there value related to that purchase offer?
Respectfully, Your Honor, the only thing on the record, I would disagree with opposing counsel's point that there was evidence on that,
Okay.
evidence to buy the consigned inventory. What there is evidence of is the portion, there was an amount of component parts that were sold to the manufacturer that Magnum retained after Airborne or after it broke its relationship with Airborne. There was an amount of component parts that were sold to the subsequent manufacturer, but not the consigned inventory, which was approximately worth that amount. So there is no evidence in the record that you're looking for, Your Honor. On the issue of statutory interpretation, this court is called upon to interpret the statute, Revised Code 1302-7A, which is the statute pertaining to seller's remedies. And essentially there's 2 questions here. First of which is, what was Airborne entitled to do as an aggrieved seller? And the second of which is, when was Airborne required to do it? With respect to the first one, the statute, the clear and unambiguous language of the statute says that Airborne, for the purposes of avoiding loss and effective realization, is entitled, that's my words, to either complete the manufacture and wholly identify the goods to the contract, or cease manufacture and resell for scrap or salvage value. Those are the explicit remedies that are provided under the code once Airborne was established to be an aggrieved seller. Now, necessarily as part of this, at the trial court level, you have the testimony of a woman named Anita Krantz, who was the account manager at Airborne, and she testified that the consigned inventory was provided by Magnum because these component parts were required to complete the manufacturing of the products themselves. They were unique to the products that Magnum had contracted with Airborne to manufacture. They were required in order to exercise its remedy. And Airborne, rightfully under the statute, could retain the consigned inventory because that's part of the party's contract. What was agreed by the parties is that Magnum would provide this consigned inventory. There was other inventory that Airborne would separately purchase, and then the final product would be manufactured and sold. We're not asking the court to interpret the statute in any other way other than the way that the contract should be enforced. The underlying purpose of the code and the underlying purpose of the seller's remedies here is to make the seller whole. In this case, the seller, Airborn Electronics, would be made whole by being permitted to retain the consigned inventory in order to exercise its clear right to either complete manufacturing or to sell those component parts for scrap or salvage value. Now, the second argument that's presented by opposing counsel is this idea that, well, they didn't do it before they filed lawsuit. Your Honors, there's nothing in the statute that provides a specific time limitation by which Airborn was required to enforce its rights. It doesn't preclude Airborn from reserving its rights. There's nothing in the statute that suggests that prior to the filing of the lawsuit, Airborn had to manufacture the goods or had to sell it. And there certainly is no suggestion or language in the statute that during the pendency of this lawsuit, Airborn was required to do it, otherwise they would waive the right to do so. We would argue that that's an unreasonable interpretation of the statute.
Well, how was the right reserved by Airborn?
Well, in a letter that was introduced at trial, Mr. Glass informed Magnum that the consigned inventory, which was worth approximately $50,000, was being retained until payment was due. And Mr. Glass testified that the reason why the inventory was being retained was to reserve its rights. He testified to that on his direct, and he also testified to that on cross-examination. So in this particular case, the only opposing counsel suggests an interpretation that Airborn was only entitled to sell that which it had. Well, there's no need for a statute, as actually the trial court points out in the argument on the trial at the court below. There's no need for a statute to enumerate the rights that the party already has. The point of the statute is to provide a remedy. And the only reasonable interpretation that provides a remedy for Airborn here is that it was allowed to reserve its rights by keeping the consigned inventory in order to complete the manufacture or to resell for scrap and salvage value. On to the second part briefly, on the conversion claim, there was no evidence presented as to what the parts were, where they came from, what they were placed into. All you have is a letter from Mr. Glass saying that he estimated that the parts were valued at $50,000 as to all 5 products. Only 2 products were submitted to the jury, the motion sensors as well as the access points. The other products were not. The jury was instructed specifically to consider the conversion claim only as to those 2 products without any evidence to be able to distinguish what the component parts were, what they were individually valued. There is not sufficient evidence to support a jury verdict on the issue of conversion, and we would ask this court to reverse. Now, as to the appeal, my opponent has made several assertions, which I will get to. Your Honor, how much time do I have left?
You have 3.5 minutes.
Thank you, Your Honor. First, with respect to the directed verdict on the 3 products, opposing counsel makes the extraordinary proposition that simply because this is a breach of contract case, expert testimony is never necessary on behalf of the defendant. Your Honor, this is not the standard, and this simply isn't true. Expert testimony is required whenever the pivotal question is outside of the knowledge of a layperson or the jury. Their assertion that Airborn breached its contract or didn't fulfill the contract is based on their argument that Airborn designed defective products. Now, the products at issue are a remote smart electronic power strip, a redesign of that power strip which never made it out of the prototype phase, and a dimmer relay, which is, as best as I can describe, is a device that helps control the dimming of the lights. The design and the propriety of these designs are not within the knowledge of a layperson. What opposing counsel is essentially asking, or asked the trial court to do, is permit the jury to speculate as to why these products malfunctioned, and to permit this to go to the jury based on a lay opinion that it did not work.
Well, I don't know from reading the briefs that there was any dispute among the parties that they didn't work. You're raising the issue of why did they not work. But as I understand the position of the appellant, it was a matter of contract, not of torts. There was no need for an expert witness.
Well, with respect to that basic proposition, just because it's a matter of contract doesn't mean that there's not a need for an expert witness. But further, to his point that it was, quote, undisputed that it didn't work, Your Honors, look to the record. The entire trial and the entire testimony of Airborne's electrical engineer, Thomas Petcavage, was hours of testimony as to why the products work, how the designs were approved by Magnum, how the products that were produced conform to the designs that were approved by Magnum, and in fact that after there was some allegations or assertion that the power strip had quote-unquote blown up, in their words, which is factually incorrect and which they have no personal knowledge of, they did testing. And he offered his expert opinion that the only thing that could have caused this type of event to occur is not the normal use of the product, but an extraordinary catastrophic external event, such as a power surge. In the face of this testimony, this expert testimony which was admitted, there was nothing to the contrary. They submitted no expert testimony to dispute this. So the fact that he could even assert that it's undisputed, it didn't work, simply is not representative of the record. But furthermore,
30 seconds, you'll need to wrap up.
thank you, Your Honor. On the issue of punitive damages, this idea that they knew, that Airborne knew what would happen to Magnum. Once again, they only point to evidence other than this idea of leverage that go to the conversion claim. They must have and provide legally sufficient evidence in order to support an award of punitive damages, and nothing was presented. They were legally barred from presenting this evidence during the first phase of the trial, and there was no evidence, as Your Honor suggests, that this was unsolicited testimony was created at the first phase. Thank you, Your Honor.
Thank you. Counsel, you have just shy of 5 minutes to.
Thanks, Judge. I'll try to make it quick. I'm going to work in reverse order. This idea that you need expert testimony to prove a breach of contract is contained in Airborne's answer brief at pages 11 and 12. And there's a little sleight of hand going on there, I'm embarrassed to say, but he cites product liability cases. In one of them, the Yamaha case, there's an alleged inclination for a vehicle to roll over. Product liability cases obviously sound in tort as opposed to contract, and they're also governed by statute. RC 2307.73A talks about the sufficiency of evidence in a product's liability case. He also leaves some words out and says the alleged breach is so obvious that it can be determined from ordinary knowledge and experience of layman's, citing the Roberts versus Holton case. That's a legal malpractice case. The words he left out were the duty of care. It's not a contract case. He also cites Price versus K&L on page 12. That's a potential structural collapse of a house case. And failure to abide by building code, it has nothing to do with this case. With regard to the identity of the products, I would add to the citation of a letter produced by Airborne or a purchase order produced by the buyer of these parts that's in my brief. There is also an additional reference. I believe it's plaintiff's 58 or 59. That is identified by Mr. Glass as being a listing of those parts. Now, as to the specificity of these parts and their special design, these are just like transistors. In fact, if I had the ability to search the transcript, the word popcorn would come up. They refer to them as popcorn. These are bags of pieces and parts that you buy and then assemble. These parts that we were trying to buy were the flour from which we would make the bread, not some special item. With regard to the aggrieved seller, I'm an aggrieved seller, therefore I have a right to commit a tort argument. That is not the law. There are lots of folks who are aggrieved thises or that's with different statuses. It doesn't give them a right to commit a tort. Now, even if this Airborn was decided to be an aggrieved seller under the UCC, that doesn't give them a right to steal our property or convert our property or commit any other tort. He left an important part out of his recitation of this remedy section of the UCC 1302.78B. He said that they had three options. One was to complete manufacture of unfinished goods or cease manufacture and resell for scrap or salvage value. Yes, if they were an aggrieved seller, they would have those remedies. The third is, or proceed in any other reasonable manner. And the court went through this and basically said, well, we're 32 months since this blow up, and you haven't completed manufacture, and you haven't sold the parts for scrap, so it's up to the jury to decide whether you proceeded in a reasonable manner. And the jury obviously decided they had not. Hearing the evidence that people were trying to buy these parts from them, if they were interested in really mitigating their alleged damages, they would have taken the money and run. But they didn't do that. They held on to those parts, and that is evidence that the jury could take and conclude that these people had a vengeful spirit with regard to allowing Magnum to proceed to have their products made by a different manufacturer. I've probably used up my 5 minutes,
Yes, you are.
and
10 seconds.
I'm finished. Thank you very much.
All right. Thank you both, gentlemen, for your presentations. The court will take the matter under advisement. We'll issue a written opinion which will be sent to both sides and do